Good afternoon, everyone, and thank you for joining us. My name is Jason Cogdell, and I'm one of two benefits attorneys at ProBenefits, and Laura Bibb is with me, and we'll be presenting in just one moment. First of all, thank you for attending our session today, which is part of our regular client webinar series for 2018. Our last webinar was in June, and we took our traditional break for July, and we'll have one webinar per month for the rest of the year. As always, this GoToWebinar session is being recorded, and we'll provide everyone that attends or registered but does not attend with a copy of the slides and a link to the YouTube recording with audio and slides. Your questions are welcome. You can submit them through the question box in the control panel, and we will try to get to those at the end of the presentation. We got a lot of content to get through today, so we probably won't answer a lot of questions during the session, but your questions are welcome. In terms of the topic, HIPAA compliance, this is actually the first HIPAA-only webinar that we have done, and I'm very pleased to bring this content to you, which we can do because of Laura's expertise. As hopefully most of you know, Laura joined our team in April, and Laura has been an attorney colleague and friend of mine for about 10 years. Laura has had a lot of experience in employee benefits and other areas of the law. She's been in private practice. She's been on the in-house benefits consulting side. So Laura really knows benefits, and she has brought some areas of expertise to ProBenefits that we did not previously have, including a lot of experience working with health plans and business associates in the area of HIPAA compliance. So even though we at ProBenefits do not have a formal HIPAA compliance service, and I'm aware that there's some entities out there that do that, our HIPAA experience is primarily in assisting employers and plans with HIPAA compliance for the plans that we administer, flexible spending accounts, health reimbursement arrangements, primarily. And we continue to assist employers with HIPAA compliance related to those plans and claims and protected health information. We do not have now and do not have plans to offer a HIPAA compliance service, so this is not an advertisement for any new service, but is a general education topic. And it is our position as compliance attorneys that HIPAA, like COBRA and regulations under the Affordable Care Act, is front page news in terms of benefits compliance and potential risk for health plans and for plan advisors. So we bring this topic to you as a matter of general compliance knowledge and education, and hopefully something that will be helpful to you employers that are on the session today representing health plans and advisors that are working with employers related to fully insured or self-funded health plans. In terms of the scope of this presentation, Laura does an excellent job, and we've got some good slides here. In the interest of time, Laura can't share everything she knows about HIPAA, which would take a very long time, and this is a complicated topic, but Laura's done a good job of breaking this down into several subtopics that we think will be good, both in terms of general education, refresher, and the discussion of common issues and best practices, again, both for employers, which is the main focus of the HIPAA presentation, and also advisors working with benefit plans. So, Laura, thanks for joining us today.
Thanks, Jason, and thanks everyone for joining us, and good afternoon. Today, we're going to provide you with an overview of the HIPAA privacy and security rules. As Jason mentioned, we're not going to go into a very deep granular level because that would take hours. We could be here talking about it again tomorrow morning if we did that. But I want to just give you an overview to allow you to really issue spot when you might have HIPAA issues or there may be things to consider. We're also going to talk about some government audit and enforcement activity. HIPAA is actually an area where we continue to see enforcement. The HHS and OCR have been funded to enforce HIPAA. Unlike some other areas of the law where I know I get asked questions all the time about audits of other plans. A common one is Section 125 plans. And we don't really have a crystal ball, but this is clearly an area that the government has taken a keen interest in. We're also going to talk about some common issues that I've seen as far as HIPAA is concerned and best practices for employers and for business associates. So before we get started, just to give you a little bit of context into HIPAA, HIPAA was first enacted in 1996. There have been several revisions since then, or regulatory changes. You may recall the HITECH Act in 2009. That was also the act that seems quite some time ago, but brought us the subsidies, along with some HIPAA changes. And our most recent final regulations were the HIPAA, what are referred to as the Omnibus Rule in 2013. And this actually came out in January of 2013. And if you were to travel back in your time machine to what was going on at that time, everyone was gearing up for the pay or play regulations, which were supposed to go into effect in January of 2014. This was before that was delayed. And on Friday afternoon, January 25th, instead of getting any guidance about pay or play, which was everyone's main focus at the time, we got 138 pages of regulations on HIPAA. So it sort of, in some ways, kind of came out of the blue as far as what was going on in the benefits world. But the compliance error continues. OCR is actively auditing and enforcing HIPAA. And it's essential that plans do it right, not only plans, but business associates as well, because breaches are costly. You'll see when we talk later in the presentation that enforcement can result in payments of penalties and fines. But not only that, there's money that has to be spent as far as notifications are concerned. So it's not just the penalties, but anytime you have a HIPAA event, it's going to be costly in terms of dollars and also in terms of people. You're going to have to designate people to manage the situation. So again, high-level overview today. The goal of HIPAA is protection of protected health information, and that's accomplished in a couple of different ways. We've got the privacy rule, which sets forth standards for protecting PHI. The security rule that sets forth standards for protection of electronic PHI, and that's going to be PHI that is in electronic format. So emails that contain attachments, files in a computer system, whereas PHI would be more of your paper forms and records that have protected health information. We also have breach notification rules, and these are the rules that strengthen the privacy and security rules. So they dictate what has to happen in the event that there is a breach. So since the goal of HIPAA is to protect PHI, it's necessary to understand what information is PHI and is therefore subject to HIPAA and what information is not considered PHI. So PHI is defined as individually identifiable health information, and there are some exclusions. We'll talk about those in just a minute. But individually identifiable health information that is maintained or transmitted by a covered entity or its business associate in any form or media. So that could be paper form or electronic. And PHI includes many common identifiers. So I've got some listed here that are common, but there are others that could be used to identify PHI. So this is an area where we, when I was in private practice and also here at ProBenefits, we get lots of questions. I think there's a lot of confusion about what is and what isn't PHI, and there are some exclusions. The biggest one is health information held by an employer as part of its employment records. So FMLA leave requests, ADA accommodation requests, drug testing that might be performed as part of pre-employment screening or continuing employment screening, workers' compensation. So all of these situations would result in the employer having health information, but since it's held in the context of an employer in its capacity as an employer and not part of the health plan, it's not going to be considered PHI. The other big area is de-identified information. This requires 18 specific identifiers being removed. So essentially, it's information for which there's no reasonable basis to identify the individual with regard to whose information is being provided. A less common exclusion in the health plan world, but probably pretty relevant in the health provider world, is health information of an individual who's been deceased for 50 or more years. That's not considered PHI under HIPAA, so it would no longer be subject to protection. So you've heard me mention covered entities and business associates. Let's talk for a minute about who those are. So covered entities, for today's purposes, we're really talking about health plans. There are other entities that are considered covered entities, such as health care providers, your doctor, hospitals, but today we're going to focus on health plans. And business associates are entities who receive or create or maintain or transmit PHI on behalf of a covered entity for a function or activity regulated by HIPAA, or provides a specified service involving access to PHI. So HIPAA actually lists 8 categories of business associates, specifically names them. Some examples include legal, consulting, administrative, data aggregation, actuarial consultants. These would all be considered business associates. There are some more difficult cases. For instance, if you've got a landlord who has access to your premises and perhaps there is PHI on the premises, a document shredding service might also be a difficult BAA case or business associate case. But when in doubt, generally it's better to err on the side of caution. If an entity is a business associate agreement is required. This is a requirement not only for the covered entity, but also the business associate itself. And then we're going to talk a little bit more in a few slides about how HIPAA impacts business associates, but just note that there are limited privacy compliance obligations for business associates.
Laura, we mentioned earlier that we have primarily 2 groups on the call today: employer, HR, benefits, or other internal folks that are effectively representing the benefit plans, the health plan, and also advisors that are working with the employer. Just to clarify and correct me on any of this, the employer contacts are going to be basically representing the covered entity, the health plan, and then the broker or agent or anybody working with the broker or agent is going to be a business associate. And assuming that is correct, is it also correct that in every case that the employer needs to have a business associate agreement with the broker the same way it would with, for example, ProBenefits, our team, if we're working with an employer on a health FSA or an HRA, if PHI is accessible by the business associate, a business associate agreement needs to be in place?
That's exactly right. So ProBenefits as a vendor, TPA is a business associate, and we have business associate agreements with all of our clients. The health plan is the covered entity, but the health plan doesn't have its own employees. So while the employer isn't a covered entity, it's going to be required to do some work on behalf of the health plan. And you're exactly right that brokers are going to be business associates for the most part. I know some brokers may have limited access or no access to PHI depending on the size of the particular group or the nature of the group. And even in that instance, I think it's helpful to have a business associate agreement that maybe just says, in the event that the business associate does have access, here are the provisions that apply, because a business associate agreement is required to disclose PHI to a business associate. And if that agreement's not in place and the PHI is disclosed, there can be some pretty stiff penalties, and I'll show you some of those examples a little bit later. So now that we know what's protected under HIPAA and who must comply, let's jump into an overview of the privacy and security rules. And we're going to start with the privacy rule first. The HIPAA privacy rule is made up of use and disclosure rules, individual rights, and administrative requirements. And each of these three areas have sub-rules or requirements underneath them. But the general rule under the use and disclosure rules is that a covered entity cannot use or disclose PHI unless permitted or required by the HIPAA rules. We're going to talk about that in a little bit more detail, because that's really, I think, where a lot of times covered entities and business associates get into trouble. There are individual rights. The one that's probably most common is the notice of privacy practices. That's a notice that most of us are fairly familiar with. And then the administrative requirements include safeguards that are essentially a mini security rule. We'll talk about the security rule in just a bit, but also requirements for policies and procedures, so documentation and training. And as I mentioned, the general rule is that the covered entity is prohibited from using or disclosing PHI unless it is allowed or required by the HIPAA privacy rules. So here we've got some allowable uses and disclosure. These are some of the uses and disclosures that are allowed under HIPAA. There is a minimum necessary standard. So even if a disclosure is allowed, it is allowed only to the extent necessary to achieve the intended result. So for example, the best example I can give of this is if you're working with an employee on a claim issue, it needs to be for a particular claim issue, and the use and disclosure should only be for that particular claim issue, not for the employee's entire claim history. And then there are, in addition to allowable uses and disclosures, there are certain mandatory disclosures. There's a mandatory disclosure to HHS in the event of a breach, but also to individuals. If they request their PHI, it's mandatory that they be provided with that information. So the focus today is on the second and third bullets of the allowable uses, the disclosure to the plan sponsor, and then disclosure to a business associate. But I just wanted you to know that there are other allowable uses and disclosures. So when we think about the compliance obligations, the funding of a health plan and the role of the plan sponsor in administering the plan, including whether the plan sponsor receives PHI, is going to impact the compliance obligations under HIPAA. So the more access the plan sponsor has, the more access the plan has, the more obligations that you're going to see. So we're going to go through some different scenarios, and you'll see that there is an escalation of obligations under HIPAA. And as I mentioned before, employers are not covered entities under HIPAA, but HIPAA does limit the PHI that a group health plan can share with a plan sponsor and imposes specific conditions for PHI to be shared. So those conditions would have to be met in order for the sharing of information to occur. So the first, probably it's simple is maybe not the right word, but kind of the first level of compliance obligation is a fully insured hands-off plan. This is going to be a plan that provides benefits through a fully insured insurance carrier. The plan does not create PHI, and neither the plan nor the plan sponsor receive PHI. So all of the information lives with the insurance carrier. The plan and the plan sponsor can receive what is referred to as summary health information. This is essentially de-identified information with the zip code included. So there's one factor that's removed from summary health information. That's the zip code that would make it de-identified. But the summary health information can be provided along with enrollment information. So the employer plan sponsor can perform enrollment functions. This is because enrollment information and disenrollment information in the hands of the employer is not considered PHI, but in the hands of the plan, the health plan is considered PHI. So for this level of compliance, there are limited privacy requirements for this type of arrangement. Specifically, the requirements against retaliation, so retaliating against an employee and requiring a waiver of HIPAA rights would apply. And all other privacy requirements are going to really reside with the carrier. There are security requirements if there is any electronic PHI, but because the employer really, and plan sponsor really aren't receiving a lot of information, the compliance may be less extensive than, say, a self-funded plan. One of the big items here of importance is if you have a fully insured plan that's hands-off and you assist employees or their spouses or dependents with claims issues, you should be receiving an individual authorization from that participant in order to assist with the claim issue. I say that even if the fully insured carrier will provide you with the information regarding this claim. This also applies to our broker attendees. If you're assisting your employer clients with claim issues, you need to be getting those authorizations as well, even if the fully insured carrier will provide you the information. And a couple of notes I wanted to make, because wellness programs are increasingly popular. A wellness program can actually jeopardize your hands-off status. So if the wellness vendor is sending health information to the employer outside of the context of the fully insured arrangement, you may find yourself no longer being hands-off. And then also confining PHI receipt to the broker from the insurance carrier doesn't necessarily keep you in a hands-off status either, because that's considered to be an action of the covered entity, the business associate doing an act on behalf of the covered entity. So we've looked at hands-off. Let's talk now about a fully insured plan hands-on. This is a plan that has access to PHI. It may be a larger employer. And then the plan can also disclose certain PHI to the plan sponsor for administrative purposes. These include claims processing and appeals, auditing, monitoring. So if the employer is involved in one of the stages of appeals or levels of appeals, the employer is going to be hands-on. And in this situation, the privacy requirements are going to apply. There's the privacy practices going to be required. We've also got security requirements if there's any EPHI, and then there are also requirements for plan document and firewalls for the employer plan sponsor. So kind of moving up in the complexity, we've got self-funded plans that are hands-on. These might be self-administered plans, which probably rarely happens unless we're maybe dealing with a health plan that's or an insurance carrier administering its own health plan, or a TPA administering the plan. And self-funded plans by nature or by definition cannot be hands-off, only fully insured plans. So our self-funded plans, the group health plan is always going to be hands-on, but we may have a plan sponsor who is hands-on or hands-off. So if the plan sponsor is hands-on for plan administrative functions, best example of this is if the plan sponsor is deciding one of the levels of appeals, then we've got the HIPAA compliance obligations that are going to kick in. A self-funded plan administered by a TPA with a hands-off plan sponsor, this is an instance where the plan sponsor is not receiving any PHI for administrative functions. The TPA is performing all of these functions. The privacy and security requirements are going to apply to the plan, but in this instance, only summary health information, enrollment, disenrollment information, and de-identified information could be shared with the plan sponsor. And I just want to note too that this plan sponsor is going to need a business associate agreement with that TPA. So we talked about plan and plan sponsor compliance obligations, but what about business associates? And prior to the prior HIPAA landscape was that a business associate agreement was essentially a contract between the business associate and the covered entity, and that contract controlled the business associate's obligations, but that's not the case anymore. So for those of you on the call who are business associates, and those of you who are planned with covered entities, it's important to know business associate obligations so you can be aware of these. Business associates are now directly, have a direct obligation to comply with some, but not all of the privacy obligations. And then there's a direct obligation to comply with the security requirements. And we're going to jump into the security rules in just a minute. Again, we've already mentioned the BAA is required. And as a business associate, you would also need to be aware of any subcontractors that you use that have access to PHI. So this might include cloud service providers. So if you're a business associate of a health plan, you have a subcontractor that is providing or helping you to provide service to your health plan client, and that service provides the subcontractor with access to PHI, then you're going to need to have a business associate agreement with that subcontractor. There's a chain of business associate agreements that can be set up. And again, just a caution about sharing PHI without a business associate agreement in place. And we've seen OCR enforcement activities and penalties for this. Most recently, we saw one with a $750,000 enforcement action and another one with a $1.5 million enforcement action. And both of those had other issues, but having a business associate associate agreement in place is a great starting point to try to be in compliance with HIPAA. So the security rule, we've talked about privacy. We're going to talk overview of security. And remember, the security rules apply to business associates and covered entities. I've got the 4 general requirements here, but really the main goal is to make sure that electronic PHI is protected. So we're looking at protecting the confidentiality and integrity of that information, making sure that we're protecting against reasonably anticipated threats or unauthorized uses, and then making sure that our workforce is trained to comply with the security requirements. So the HIPAA security rule, there are a variety of security or ways to achieve compliance with the security measures. There are some things that have to be done, but a lot of times there are different ways to achieve the same result, and the rules specify those, but everything starts with a risk analysis. So if there's no risk analysis, as with any other type of policy, if you were doing a general risk policy of your organization, you can't understand your vulnerabilities and implement policies and procedures to address those unless you understand what risks there are. So you can see here the considerations that you have to take into account when doing this risk analysis. And it's not a one-size-fits-all almost. It's going to be specifically tailored to your particular situation. And these requirements are met by applying specific standards and implementation specifications. So under the security rule, there you can see there are 5 areas of safeguards that are required. Within these 5, there are actually 22 standards that have to be met. So it's much more detailed than what's on this slide, but this gives you an idea of what type of protections are required. So what happens if there is an unauthorized use or disclosure under the privacy or security rules? In that instance, the breach notification rules come into play. And a breach is defined as the acquisition, access, use, or disclosure of unsecured PHI, and that's very important, unsecured PHI, in a manner not permitted by the privacy rule. So it's not a permitted use or disclosure, which compromises the security or privacy of the PHI. And there are some exceptions, but generally, as far as PHI is concerned and securing it, there are only 2 ways to do that. Encryption for ePHI and destruction, if we're talking about paper versions of PHI. And if there is a breach, or if there is an incident, there is a presumption of a breach. So you're presumed to have breached the HIPAA rules unless there's a low probability that the PHI has actually been compromised. And this requires a risk assessment on the covered entities' behalf. There's no de minimis exception, so it doesn't matter how small or how little PHI may be impacted. You still have to go through this risk analysis, and the burden is on the covered entity to prove that the breach notification was not required if it determines that there wasn't truly a breach. So if it's determined that there is a breach of unsecured PHI, then there are notification requirements in place. And these are the notification requirements to the covered entity, first and foremost to the individual affected or individuals affected within 60 days after the discovery. And this is really an outside time frame. The HIPAA rules provide that it has to be without unreasonable delay. So you can't wait until day 60 to provide the notification if that would be an unreasonable delay. And if you've affected 500 or more people in one state, then you get to be on the nightly news. That's probably no fun. And even less fun maybe is informing HHS that you have had a breach. So if there are 500 or fewer, fewer than 500 affected, you are going to be logging once a year. But if there are 500 or more affected, then you have to log per incident. And I've got down here the website for breach notification. I call this the HIPAA naughty list. You can go look at it and see who's done what. There's specific information about which entity, whether they're a covered entity, health plan, provider, business associate, what type of breach there was, what happened. So not a list that anyone wants to be on. Business associates also have notification responsibilities. The business associate generally must notify the covered entity within 60 days of its discovery of a breach. So this is an incident, this is a situation where the business associate has had a breach. They are going to have to notify the covered entity of that breach, and then the covered entity would have to go through its breach notification processes and procedures. The business associate agreement may provide for other notifications. So sometimes you may see a business associate agreement that includes a provision that the business associate will actually notify individuals. So it's important to check those agreements and make sure you understand what the contractual obligations are. So let's shift gears now and talk about how these rules are enforced. HHS has delegated its authority to enforce HIPAA to OCR, and that stands for the Office of Civil Rights. OCR's enforcement of HIPAA is through a variety of methods. It can include complaints and investigations. If someone believes that their PHI has been improperly used or disclosed, they can always call and complain. HIPAA audits, resolution agreements. These are agreements where a covered entity or a business associate agrees to a corrective action plan, so steps they're going to take to become HIPAA compliant, and a monetary payment. Civil monetary penalties, this is really, these are situations where a covered entity or business associate is really just not been cooperative with OCR, and the penalties here are based on culpability. OCR actually prefers resolution agreements because it allows them to make sure that changes are being put in place to ensure compliance. There are other enforcement activities that can happen, including criminal penalties, and being on that naughty list that I mentioned earlier is a really good way to ensure yourself a visit from OCR. So those breach notifications are likely going to trigger an investigation. We talked about HIPAA audits as a compliance mechanism. The HITECH Act actually required HHS to conduct proactive audits of covered entities and business associates, and these were actually financed in the budget for HHS and OCR. So there was some meat behind, or some bite behind this, I guess I should say. There are two phases of audits. Phase 1 is complete. Phase 2 is ongoing. Right now, we've got ongoing desk audits of business associates, and then we're going to be having a third set of audits that are on-site and more broad in scope than the desk audits. I just want to note for you that the audit protocol is online, so if you're interested in looking at that as part of your HIPAA compliance approach, you can access that information. One important thing to know is that there's only 10 days to respond. So this really isn't a situation where you can get your audit letter and put something together. You really need to be prepared in advance. So let's look now at some enforcement activities. This is a 2016 case. This was actually only the second ever civil monetary penalty for a covered entity. This involved a situation where the wife, who was the employee, left behind PHI of almost 300 patients when she moved out of her marital home due to a separation or divorce. The covered entity was notified by her estranged spouse, and the breach was reported. An investigation revealed that employees regularly removed PHI from their work premises, and there was a civil monetary penalty of almost $240,000. These are some 2018 cases. This covered entity is a healthcare provider that reported 5 small breaches of PHI over a 6-month period. The penalty was $3.5 million, and you can see that that is a lot of money. And you can see the investigation revealed there were some pretty reckless things going on, lots of laptops stolen, a list of passwords. So I do have to say, sort of as a benefits attorney, reading these things does give me lots of pause. Seeing a list of passwords, and those lists being left in someone's car, unencrypted USB drives being stolen from a car. So this covered entity got the $3.5 million penalty and 2 years of continuing OCR involvement through a corrective action plan. The next one is Filefax. This is a business associate There was an anonymous complaint to OCR that an individual was trying to sell PHI from an unlocked truck. Again, kind of gives you great pause. Not surprisingly, this company went out of business. The receiver agreed to pay $100,000 penalty and catalog and dispose of the records in the business's possession. And this is an example of not having a BAA. So this covered entity sort of caught in the crosshairs here, couldn't produce a BAA with this entity file fax, and that cost them $31,000. So that was a pretty expensive mistake. So we've looked at some enforcement examples where entities didn't get HIPAA right. Let's close up by talking about some common issues and best practices. So this slide here is a list of some common issues that come up and seem to be recurrent themes in the breach notification and resolution agreements. The first common issue is not understanding PHI access or losing hands-off status. So the covered entity doesn't understand whether it's hands-on or hands-off, or it does think it's hands-off and then it does things that would cause it to lose that hands-off status. This next one is a huge issue, our increasingly mobile environment. Lots of risk here. We've got teleworkers who are out and about. We've got people on airplanes. I know when you see someone on a computer, I think it's human nature for people to look over, whether that's in a coffee shop or on an airplane, and being aware of public Wi-Fi. So those generally aren't secure connections. USB drives, external hard drives, laptops, cell phones, pretty much anything that can grow legs or be left behind. A great example is you're running late to your flight and you jump in an airport taxi and you jump out of your airport taxi when you get to the airport, but your phone does not jump out with you. So then you've left your cell phone that might have PHI on it. Auto population of email addresses. So I'm sending an email, and this is a hypothetical, but I'm sending an email with PHI to Jason, and instead of sending it to Jason, I send it to Jason Smith, because when I type in Jason Smith's email auto-populates. That's a big and common issue. Printers and scanners that retain memory, they may contain PHI on them, and you need to address wiping these clean or destruction of these items. Unsecured PHI, making sure that you encrypt. If you are sending an email with PHI in it, make sure that you send it encrypted. Failure to have a BAA, security weaknesses, hacking, etc. Hacking is a big issue right now, I think generally in the world, but also in the HIPAA world. And just be mindful of the fact that employees can be weak links. If they aren't trained, they don't understand, they may create situations where hacking is likely to occur, or introduction of viruses, etc. So best practices, make sure you understand how PHI, ePHI is handled. Where does it live? Is it in your file servers? Does the BA have it? Does the insurance carrier have it? Where is it? And then who has access? Does the plan sponsor have access? You need to make sure that you understand these things. If the plan sponsor is receiving PHI, and also for our business associates, make sure you understand which employees need access to PHI. Not all employees, whether with the plan sponsor or business associate, are actually going to need access to PHI. We need to make sure that there's a firewall in place. Again, encryption, encrypt. Know who your business associates are and make sure that you have agreements with them. Same is true for business associates. Make sure that you have BAAs, not only with your covered entity clients, but with your subcontractors. If the security rule applies, you have to do a risk analysis. That's the starting point. Make sure that you're documenting, that it's not one size fits all. It needs to be tailored and specific. And there's a 6-year general rule of documentation retention. HIPAA compliance is ongoing and evolving. So as technology advances, so should the policies and procedure. And also as the sophistication changes, as a plan, if you're moving from fully insured to self-funding, that's going to require ongoing evaluation of HIPAA obligations. And then lastly, be prepared and be organized. Make sure that you are prepared, that you're organized, you have your materials together. Just as a reminder, that 10-day notice for a HIPAA audit is very short. So it's best to be prepared ahead of time.
Laura, thank you. This is a big and complicated topic, and you've done a good job of simplifying it down to what we need to hear in some of these key topics. And obviously there are more levels and more depth to HIPAA, but these are the key core concepts. And for you employers, I hope that you found this helpful. I hope that you clearly understood from Laura's description the fully insured hands-on, hands-off, or self-funded hands-off levels of compliance, and got an idea of what that means for you and what may need to be done. Certainly, we would recommend that HIPAA issues for your organization be addressed sometime soon, sooner rather than later. And even if you don't have time at this exact moment, this is an action item that is valuable and certainly relevant in terms of minimizing any potential risk for your organization. So, Laura, thank you. Laura and I at this time are going to shift into some Q&A. If you have submitted a question or would like to submit a question in the next few minutes, we're going to hang around for 5 or 10 minutes to get those questions answered, which we're going to do largely in writing. So for those of you that have not submitted a question and don't have one, thank you for attending, and we appreciate your time. You'll get a follow-up email from us with information about this session, and you'll in the next couple of weeks receive an invitation for our September webinar as well. So thank you for your time. And again, those of you that have a question or would like to submit one, please use the question box on the control panel to submit your question, and we'll get to those as we can in the next few minutes.
And one of the questions, I've actually seen a couple of questions about individual authorizations. I'll just chat about that, and I'll put the response here in writing too. But those individual authorizations should be in writing. That was one of the questions. So it would typically be a form that's provided to the participant.
Yeah, Laura, I'm keying that in now. So. Some of the questions submitted relate to whether we will provide a copy of the presentation, which we of course will. You should get an email from us sometime in the next day or so, which includes a copy of the slides, a link to the YouTube recording of the presentation. But if you'd like any more reference information on any of the topics that came up today, we'll be happy to provide that. You're welcome to either respond to the webinar email with that request, or to send a separate request to compliance@ProBenefits.com. Compliance@ProBenefits.com is the best way to reach our team. Laura, with that, I'm going to close down the audio, and we'll continue to monitor the written questions as they come in. Again, thank you for your time. Laura and I'll be here for 5 to 10 more minutes answering questions in writing if you have any questions to submit. Thanks, and have a great day.